Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-5173, America First Legal Foundation Appellants versus United States Department of Agriculture et al. Mr. Epstein for the appellant, Mr. Sandberg for the appellees.
Good morning, Mr. Epstein. You may approach the bench, and if you want to adjust the height, feel free.
I think it'll work. Good morning, Your Honors, and may it please the court. My name is Daniel Epstein, and I'm counsel to America First Legal Appellants in this case. With me at co-counsel table is Michael Dang. I'd like to reserve 1 minute for rebuttal. This case concerns the tension between the president's confidentiality interests and the public's right to know about government's operations. This court should reverse the lower court or otherwise remand for a segregability analysis for 3 reasons. The first is that the plans submitted from the agencies under the executive order reveal nothing about presidential decision-making. Second, the White House affidavit pointed to by appellees in this case interpreting the executive order, and which is raised for the first time in litigation, warrants no deference by this court. And lastly, failing to either reverse or remand spells terrible policy implications for the public. As to the first argument, that nothing the agencies created in response to the voting rights executive order reveals anything about presidential decision-making. As this court well knows, the landmark case for the presidential communications privilege is in Seald's case, dealing with former Agriculture Secretary Mike Espy in a special counsel investigation. There, the core of the presidential communications privilege applies to documents that reflect presidential decision-making and deliberations. And of course, that case limited the scope of PCP to internal White House communications.
I'm not sure I follow, because didn't we hold there that communications by presidential advisors in preparing the president to make a decision are privileged?
Your Honor, the issue in Seald's case actually dealt with who becomes a close presidential advisor. And so presumably before that, the assumption was that the president needed to be the one who was advised about something that needed to be confidential. Of course, what this circuit now recognizes is that you could have lower level individuals within the White House, like a special assistant to the president, who nevertheless has official duties that relate to presidential decision-making.
Right, but so that case, the main issue was about how far down the line the privilege extends, but I thought you were making a point that it had to reveal something about White House decision-making, so the inputs to decision-making are somehow not covered, but that seems pretty clearly established that the inputs are covered. So I'm not sure.
Yeah.
I just am probing what you mean by it doesn't reveal anything about decision-making, because we've held, I think repeatedly, that the kind of information that advisors believe is relevant, or as here, that the president himself solicits, are actually revealing of the nature of the decision.
Well, Your Honor, I think the answer is that it actually depends. So most of the times that this circuit has looked beyond internal White House communications, and particularly lower courts in the circuit and the DDC have looked beyond White House communications to say, here we have a presumed solicitation, we have a presumed submission or communication from the agency, and the last factor is this relates to some presidential decision-making. Universally, that has either been internal White House communications, and those cases have not involved FOIA cases. Those are congressional oversight cases. Some of them were Federal Advisory Committee Act cases. But in the FOIA context, most of the time, what we're dealing with is one agency or one principal at an agency making a communication. Here, what I think is incredibly odd about this case is this is not a particularized solicitation of advice. This is an executive order, which goes to all agencies. And in fact, it should be kind of the reverse presumption, which is to say, if you're truly interested as a close advisor to the president or the president himself in getting confidential communications, an executive order is an incredibly blunt tool to do that. You will often directly solicit communications. you don't effectively advertise your communications through an executive order. And I think
So
that
just to understand the
Yeah.
legal rule
Yeah.
you're proposing, if this EO had just said, all agencies send me a list of recommendations for me to make future decisions, are you disputing that that would be covered by the privilege?
Well, again, Your Honor, I think it depends. First of all, as a rule, right, we know what the rule is, and I'm not disputing what the rule in this circuit is that you need the president or a close advisor to the president to specifically solicit and receive a communication that is relevant to presidential decision-making. I think there's a number of issues here. One is the question of whether the responsive communications here reveal anything about presidential decision-making. Recall, this case is not about internal White House deliberations. In fact, it's not about deliberations at all. Nothing in the record indicates that there was some give and take between the White House and the agency regarding these plans. In fact, when you look at Special Counsel Sauber's declaration, he specifically says that the purpose of these plans was so that the agencies can formulate the activities that they want to engage in. That's clear by its factual definition, something that's not related to presidential decision-making.
I thought on pages 124 to 25 of the JA, Special Counsel Sauber pretty clearly says that these were solicited by the White House to be used for briefing and decisions by the president. Is that not the case?
Well, Judge Garcia, I think there's a lot of things to be said there, and I want to go back to your prior point. But the first is obviously we dispute that the executive order said anything that even comes close to soliciting confidential communications. And to the extent that the Sauber declaration rather says anything about the purpose being to advise the president, that is nowhere in the text of Section 3B of the executive order.
Absolutely. So I appreciate that argument. It's just that you had said there's nothing in the record that reflects it. And I would just say this framing of the case seems the way you would ask us to look at it is essentially Mr. Sauber says the words that would qualify this for protection, but that's contradicted by other evidence in the record. And so you talk about the EO and the agency declarations, et cetera, et cetera.
Right.
But that's really the argument, that we should find this is rebutted by contrary evidence. Is that fair?
I think that's an alternative argument, Your Honor. And I think that if this court was to say, look, we have conflicting evidence, obviously you're on the posture of a motion for summary judgment, and you're looking at a summary judgment standard. And I think that would warrant this court saying, look, there's actually some more fact finding that the district court needs to do. Let's remand, kind of similar to what has happened in the parallel case in the Middle District of Florida. Let's do a potential segregability analysis. Let's look at the facts. But I want to go to your earlier point, Judge Garcia, and that is on the question of, well, isn't it well established that if you have these factors, solicitation, receipt in response solicitation, and it's for the purpose of presidential decision-making, then we have a slam dunk answer that this is subject to the presidential communications privilege. And I don't think it's so clear in this circuit. First of all, we have a lot of case law that indicates that when you look at the situation of moving beyond the White House, and you're looking at the executive branch agencies, one of the core factors is, does this involve a non-delegable duty? Here, whether the president wants to be advised or to think about planning for voting rights is certainly not one of the kind of core non-delegable duties of the president.
Why does that matter? I mean, I understood that if you have a non-delegable duty, that it's especially clear that whatever advice is being provided is provided to the president, because no decision can be made or foregone without the president's having been the relevant actor. But I don't take anything in the logic of our cases about presidential decision-making to limit it to that. I recognize that's the strongest case, but for example, the president has the obligation to take care that the laws be faithfully executed. And if the president is, fulfilling that obligation and authority, why isn't he entitled to confidentiality in the advice he receives and how to do that?
Your Honor, those are excellent questions. Let me address them in turn. First, I actually do think this circuit has a limiting principle and why the kind of non-delegable duty question does a lot of work in this circuit. And that is the language that you've seen in the Judicial Watch versus Justice Department case and other cases that say that the assertion of the privilege must be narrowly circumscribed, right? And so all of a sudden, if we expand it with the agencies, not only to non-delegable duties or to delegable duties being covered by the privilege rather, and we apply it not just to a specific type of normal a standard case of confidential communication, a presidential advisor to one agency individual. But say that it could be throughout the executive branch, through an executive order. That is certainly not narrowly circumscribed, and I think that has very serious implications. I think the second thing to address your point about, well, the president has to take care that the laws are faithfully executed. In order to do that, he has all of these needs for confidentiality. And I think it relates to the earlier point, which is that certainly the president doesn't take care that the laws are faithfully executed by going on a speakerphone and talking to all agency heads at the same time. And that is effectively the tool that the appellees argue is being used here and should be justified as presenting kind of confidential communications.
I'm not sure I follow the logic of that, because if a president comes into office and says, you know, I'm on a listening tour for my first 100 days, I want to know from each agency what they think are the available policy options and what they would recommend. You could say that in a conference call and then say, you know, when you respond to me, we'll have a confidential one-on-one phone conversation. And it seems to me that that would be covered, even though it has the wholesale rather than retail aspect. I don't think that vitiates it. So I'm just trying to figure out what the wholesale or the executive order aspect of this, what work you really think that's.
I see my time is expiring. Can I answer this question?
Continue.
Okay.
You may know we have a rule that as long as we have questions, we'll.
So I think this hypothetical is actually perfect, because what you've presented is a situation in which the president has a political or policy interest in announcing kind of his interests of getting educated by the agencies. And then second to that, has his staff engage in one-on-one confidential communications. And that is precisely the sort of facts that the presidential communications privilege ought to protect. Not the sort of thing that you announce something big in an executive order, and then only after the fact, behind the scenes, do you develop a template and have a Office of Management and Budget website to submit. That is not how you engage in the sorts of traditional cases of communications that this circuit has said should be presumed to be protected by the privilege. And the last thing that I'll say about your point, Your Honor, is that one of the implications of saying that we can have an executive order, we don't need to rescind the executive order to change the meaning. We could just implement it through all sorts of other systems in which we've engaged in, and which is in the record, is that the public doesn't know what the executive order means. Executive orders are published in the Federal Register. Executive orders lead to policymaking. There's a big presumption that if an executive order is going to say this is confidential information, it will say that. There's a reason why executive orders don't say this is confidential information, because executive orders are really bad ways for presidents to get that information. And presidents typically don't want to publish policies in the Federal Register if they want responses to be confidential. And so with all of this, we can't just think of the implications for the FOIA requester community. We also have to think of the implications for Congress, which is
So counsel, just on the meaning of the EO, because this is the crux of your argument. I think the government might say what is public is the request for plans. And the question is then, what is the plan that was submitted? And they just point to the language that says, essentially, please identify the ways that you can promote voter registration. And their view is that that's essentially asking for a list of options for the White House to then consider, give feedback, maybe take other action on. And that it's totally consistent with the district court's ruling that these were inputs into presidential decision-making. And I'd just like to hear your direct response to that.
Yeah, so Your Honor, of course, what you have here is a series of public documents, the plain text of the executive order, the White House fact sheet. Typically, executive orders come with an Office of Management and Budget interpretive memorandum.
My question is on the plain text of the EO. why should we read, submit a plan outlining the ways you can promote voter registration to mean, tell us all the ways you have decided to promote voter registration?
Yeah. So, and sorry, Your Honor, two reasons. One is an agency plan for its agency purpose is not a White House purpose, right? If the language said for the purpose of the president engaging in some policymaking decision, then we would have a clear indicia in the executive order that there was a presumption of privilege.
That's so interesting because I read it as distinct from recommendations, asking for capabilities. What can each agency do? Tell us about how you interact with the public. Tell us about, what kind of ID you issue. Tell us about, what your websites are, and don't bother to sort of stress about formulating recommendations. You're not, voter participation experts. Just tell us about your capabilities and we'll get all that. And then we'll try to come up with something that's sort of, coherent and cross-cutting and straightforward that's worthwhile. So what about the executive order contradicts that understanding?
Well, Your Honor, let's assume that your understanding is the right understanding. Then what we have there is we have all sorts of data that the agency produces to the White House. And to your point, that then leads to some give and take between the White House and the agency about, let's try to formulate the plan. That give and take is presumed to be subject to the presidential communications privilege. What the agency produces for submission to the White House involves nothing about deliberations between the White House and the executive branch. And in fact, doesn't reveal anything about presidential decision-making.
So
let me just follow
I'm
up
sorry,
on
go
Judge
ahead.
Pillard's question, if I may, counsel. This is Judge Rogers. Is the court to ignore the context in which this executive order was issued?
I'm not sure I understand your question.
Well, let me be clear.
Thank you.
This is March of the president's first year. After how many lawsuits were filed contesting the election results? All right. So the president is in office, and by the time he gets his staff organized and all, it's March, and he says, one of the things we ought to do is check what the agencies are doing. So send out a notice to the agencies along the lines that Judge Pillard suggests. And while you contest, well, it shouldn't be done by executive order, maybe from points of efficiency, that was the better way, rather than send thousands of emails and letters to individual agencies. I'm not quite understanding your argument here as what I thought your argument in the brief was, and maybe the government's response persuaded you that there was no merit to the notion that here the executive order was as a result of soliciting information that could be deemed to be within the presidential communications privilege was too broad, because it was asking for things that the agencies had already done, which are a matter of public record, as well as what more they should do. So you reject entirely the notion that a president is entitled to ask the agencies for information about what they're doing, so he can make a determination about what more should be done, what kind of coordination there should be, and what kind of oversight.
Well, Your Honor, I think I understand your question, and
What don't you understand about it?
No, I think I understand it. Sorry, I understand the question, and I think, of course, the president can solicit information that the executive branch agencies produce. The concern here is what is the limiting principle on that? Can the president request that an agency, when it creates a record that might at some point be subject to a congressional subpoena, can the president say, please provide that record to me, and therefore we're going to be able to assert privilege so that Congress?
That's not this case.
Well, and a follow-up on that, unless Judge Rogers has one.
Please.
So am I wrong that if a FOIA request were sought against the 14 agency defendants in this case, asking them what actions have you taken to, provide documents relating to actions that you have taken to increase public access to voter registration materials? Or do you have any policies on access to voter registration materials? Asked in that way, I would assume that it would be permissible. It's sort of like attorney-client privilege. You can ask facts. You just can't say, what did you talk about with your lawyer? And so here, I actually, so maybe a more useful, this is getting to my, trying to understand your concern that sustaining the district court here could throw kind of a cloak of secrecy over a lot of materials. And I'm not understanding it that way, but maybe you can describe the fearsome situation.
Yeah, and apologies if I wasn't so clear. I think to go to some of Judge Garcia's questioning is we could just look at the record and say some things are public, some things are not, right? It was not public that the White House created templates. It was not public that the White House created, or rather Office of Management and Budget created a website for the agencies to submit information to. It was public that there was an executive order. It was public that there was a fact sheet. And so what is problematic is you could have a series of executive orders that look very similar to this one, but the public has no way to assess, well, is this going to be one of those executive orders where at some point of time, and by the way, we're not told in the declaration when that time was, where all of a sudden the White House could develop a template and develop a website, and that therefore becomes the solicitation that prevents us from getting public access to records? That would be a very difficult policy for the transparency community, because it would effectively chill them from seeking information.
Is there an answer in that to the question that I posed about whether a FOIA request, even were under the district court's approach, could a FOIA request be made directly to an agency asking for particular kinds of information?
Yes, Your Honor. FOIA requests could be made
and not be blocked by a presidential communications bill.
Sure. So you could write a FOIA request that says, do emails exist between the agency and the White House, or some formulation like that?
But I'm trying to get when you're talking about the information that would be shielded, when you're talking about communications with the White House, that is presumptively shielded. But I'm saying that if you wanted to know what the agencies themselves are actually doing, on your presumption that this was saying, go forth and do all the things you can do, that the executive order meant to say, go forth, agencies, do all the things you can do, then is there anything to stop a FOIA request directly asking the agencies, apart from any communication with the White House? Yes,
I understand your question.
And so
I think the appellee's position would be whether those documents constitute a plan or whether they constitute what may look like a plan, the presidential communications privilege will apply so long as that data went to the White House and was then presented to a close advisor of the president.
Maybe I'm not being clear, but the submissions, the template as filled out would not be obtainable under FOIA. But when you talk about secret law and the agencies actually doing things that the public doesn't know about, it's that aspect. Like, if you're right that what the president was asking for was agencies have at it, go come up with a lot of stuff. And if the agencies then do that, putting aside the president's role and the submission of these templates, that activity is still presumably subject to FOIA. But that's not what you're interested in.
Well,
in this case, but I'm just trying to understand
Your Honor,
claim that it casts this sort of secrecy cloak over a lot of functioning of government.
Your Honor, I think to your hypothetical, I think the appellees would in fact say that everything that you're talking about would be subject to the presidential communications privilege. How do we know? Because when plans were released to another FOIA requester, the White House took the position that that was inadvertent.
That's
I
the
think-
strategic plans, though, not,
Well, but
Policy
then
action.
what's the daylight between a strategic plan and then information that might be responsive to the executive order that wasn't put into the strategic plan document itself? And I think the test at this
Counselor, I
point,
think the question is, could you have written a FOIA request to the agencies to describe all the final agency actions they took in response to this executive order? And I believe the answer could be wrong, so that's not this case, but is obviously yes. What you can't get are the deliberative documents within the agency, and maybe in this case, if they are deliberative, the documents between the agency and the White House.
Your Honor, that is a phenomenal question because my response is that in fact, our position is that the agency plans were final agency documents
I understand.
before they went to the transom of the White House. And the key question here is would producing that document, not any of the internal White House deliberations, not any of the back and forth with the agencies, is producing that plan going to interfere with presidential decision-making? And the answer is obviously not.
Thank you. I just had one final question, which is you raised this argument about whether a quintessential and non-delegable power is involved. And either now or on rebuttal, I'd like to know if there's somewhere in your opening brief that you raised that argument.
So to be frank, I think we didn't raise it specifically, other than the case law we cited deals with this issue repeatedly.
Thank you.
Thank you very much.
I don't know if Judge Rogers or Judge Pillar
sorry.
has any final questions.
my only question is,
Okay.
I saw that there's a template in the joint appendix that's called interim strategic plan. Do you know if there's a template that's non-interim in the record? This is maybe a better question for the government.
Yeah, I mean, my understanding based off my review of the Sauber Declaration is that there were just templates. But, you know,
So this is
Appleese,
the template as far as you know.
that's how, as far as I know.
And the fact that it refers multiple times to, it directs the agency to briefly describe potential agency actions. That doesn't contradict your reading of the executive order as effectively directing agencies to go ahead and take action,
Well,
as
so
opposed to wait for,
Yeah.
presidential policy.
yeah, I mean, I think the law of this circuit, Your Honor, ultimately looks also at the question of what is the proposed use? And if you, we have all sorts of cases in this circuit where this court has said that if you really want to manifest your intent to control your document or to otherwise make sure it remains confidential, you should manifest that clearly. We have all sorts of instances of the White House entering into memorandum of understanding. We've seen that with FBI background investigations, for instance. We've seen that with Secret Service records, for instance. And I think this court looks at the record and has to determine when we see use or agency purpose or anything like that, is it for a White House purpose where the White House has retained control over those deliberations, or is it for an agency purpose? And it might be the case that this court decides, look, it may be for an agency purpose, but it nevertheless may be subject to deliberative process privilege. That is a different question than whether the presidential communications privilege applies.
Judge Rogers, do you have any further questions?
No, thank you.
Thank you, and we'll give you your.
Thank you very much, Your Honors.
All right, and now we'll hear from Mr. Sandberg.
Good morning, Your Honors, and may it please the court. Jeff Sandberg for the 14 agency defendants. As some of Your Honors' questions reflect, this case is about a very narrow class of documents. It is documents prepared at the president's express request, submitted to his senior most domestic policy advisor, laying out a panoply of policy ideas and proposals for White House consideration. These are inputs into presidential and administration decision-making. It is, in the words of the In re Sealed case, it is a comprehensive exploration of all policy alternatives. And there, as I think Judge Pillar's question got at earlier, there's no requirement that these inputs themselves reflect the outputs of presidential decision-making. The fact that they constitute advice to the president via his domestic policy advisor brings them within the heartland of the presidential communications privilege. The executive order, I get that what feels different about this case for my opposing colleague is that the president conveyed his request via an executive order rather than via speakerphone to all agencies, as he suggested. But I think if anything that furthers rather than inhibits transparency, the government has received many, many, many FOIA requests about implementation of this executive order. And we have responded with the documents that we can disclose that, as Judge Garcia had asked about, that don't reflect deliberative material and that don't reflect presidential communications. I think we're in violent agreement with our opposing colleagues here that they are entitled to know about the operative commitments of the agencies and their effective policy. They just need to ask the agency for documents reflecting those policies. What they're not allowed to do is to say, well, that sounds like it might involve dozens of pages. I want one-stop shopping and get a list of alternatives. And for most of these plans, they include ideas that never got off the drawing board or weren't or were decided against or weren't implemented as proposed. And that is from the very outset of the presidential communications privilege in the Nixon case. The Supreme Court said a president and those who assist him must be free to consider different policy alternatives without the public looking over their shoulder.
What if we read the executive order, as Mr. Epstein does, as telling the agencies not recommend things, but do everything you can along the following lines to increase access to voter registration and information about voter registration, and we'll stand ready as the White House to do oversight, and if there's any additional policy tweaks needed, we'll respond to that. Would that change your analysis?
Well, it certainly is not a plausible reading of the executive order, Your Honor. As the district court explained, the most reasonable reading of this is calling for what I think Your Honor termed capabilities of agencies, things that they can do rather than things that they will do. The fact that the executive order didn't use a magic word, recommendations, doesn't defeat that that's the most natural reading of that. And then you have the Sauber Declaration and the agency declarations that come in and confirm that that natural reading of the executive order is in fact the correct one. That is, the documents as they exist in the real world are lists of policy proposals rather than lists of final agency actions. And of course, we're not focused here on what hypothetical documents might be, what other kinds of documents might hypothetically be responsive to the executive order. The question under FOIA is, look at these actual agency records. Are they or are they not privileged? And it's not post hoc or retroactive for the agency and White House declarants to come in and say that is the character of these documents. That's just how FOIA works.
Can I just ask a question, and this is a hypothetical, right? If the president had just asked agencies for all the things you've done over the past 5 years in this area, but then it was very obvious that the president and the White House actually used that to inform presidential decision-making, would that still be protected? In other words, it seems like the ultimate question is the document, the ultimate question on your view is whatever the document is used for presidential decision-making? And in this case, the fact that you say they're potential and not final actions it furthers that argument, but is it essential?
I know this answer isn't satisfactory, but I would have to know more about the circumstances to know whether it really is reflective of, as this court's precedent says, reflective of presidential decision-making and deliberations. We're not asking this court to address that question. We don't want this court to go down any slippery slopes here that it's not comfortable going down. In Ray Sealed case actually contemplate pretty clearly that certain kinds of post-decisional or factual information would be covered by the privilege where it is sufficiently connected to presidential decision-making. But here, all this court needs to say is that the declarations confirm that these are inputs into presidential decision-making and that they are lists of ideas, and you don't need to go any further than that.
How, though, I mean, that seems like that could be potentially very broad. If a presidential decision includes a decision not to act, if presidential decisions include potential oversight with an uncertain prospect of policy, and the president asks for particular matters, raising red flags potentially about the president's intent, whether it's a lawful or a Hatch Act violative concern. I mean, I'm just sort of spinning out, I think, where the challenge is coming from. What are the things you can point to that appropriately confine the privilege narrowly as our precedents emphasize
Well,
must be.
Yeah, I think the limiting principle here is the one set forth in Judge Rogers' opinion for the court 20 years ago, which is that documents that are flowing in with advice to the president are protected by the privilege, but agency documents within the agency itself are not. And certainly the documents flowing into the White House need to be connected to presidential deliberate decision-making and deliberations. And here, this court can just say that that's abundantly clear. It's abundantly clear the White House was involved. The fact sheet that was announced that reflected certain agency actions that had already been vetted with White House approval being announced reflects the White House's involvement here. This wasn't just a case of, tell me everything you're doing and I'll speak up if I want to say anything about it. I mean, the president said this is a core domestic policy goal of mine. I'm announcing it to everyone. And get back to me with your ideas and we'll take it from there.
So am I right that it's the form of the document going to the White House, the fact that it's going to the White House, that's privileged, as template because it's generated and solicited by the White House is privileged, but that the information contained, as I think you said when you started, is not?
Well, it's kind of a technical objection in a way, Your Honor. They can't get this document, but they can get all the information in the document if it's contained in some other agency document. And a lot of this stuff has been made public in response to other requesters. Your Honor asked about the final version of the template. It's not in the record in this case, but it has been released under FOIA. I believe at least the Heritage Foundation has a page that collects certain documents that were released under FOIA. And I haven't independently confirmed the authenticity, but there is a final strategic plan template on there.
What's the role of the interim and the final? Can you just give us some context on that?
My understanding is just that the White House, so the executive order calls for submission of a plan 200 days after the executive order. But there are many agencies who are, really interested in these ideas and followed up immediately with the White House about different ideas. And so it ended up being that there was a lot of back and forth between the Domestic Policy Council and individual agencies. And at some point, an interim template was provided to them to help guide them in their initial spitballing of ideas, you might say. And not all agencies engaged in that early spitballing. I mean, some of these plans that came in after 200 days contain just lists of ideas that were never implemented. But other agencies that had been engaged with the White House more ahead of time were able to report on things that were, announced around the same time. These plans are a snapshot in time of the status of the comprehensive efforts of the White House to explore different policy alternatives.
So there weren't two waves of submissions. The interim was just like a worksheet for the agencies, and then they submitted on the final.
I'm actually not sure, Your Honor. I'm not sure whether the interim templates reached the White House. Those weren't requested here. What was requested was the final documents submitted in September. If there are no further questions, we'd ask that the judgment be affirmed.
So what about the Kaiser question that Mr. Epstein's briefing has raised? If we think that there is, genuine ambiguity in the executive order about what it is requesting, would this be a case in which there's any kind of deference? How do we think about that?
We don't see it as a Kaiser question, Your Honor, because we're not saying that the executive order is like the law that controls here. Rather, the law that controls here is this court's FOIA case law and presidential communications privilege case law. What the executive order is a piece of evidence, factual evidence that the president solicited these communications. And if, the face of the executive order called for, a submission of final agency plans reflecting actions already taken, and then the Sauber Declaration said something contrary to that, you would then have a contradiction between the declaration and the executive order. But here, the Sauber Declaration confirms rather than contradicts the natural reading of the executive order. So we're not asking for deference. We're just saying that our declarations confirm what the actual, character of these documents in the real world is, and that's not inconsistent with what the executive order had called for.
And does it matter for applicability or not of deference or of Kaiser whether the executive order regulates private conduct or is just a communication to other aspects of the government? Or
I don't want to get out ahead of the Solicitor General on the potential application of Kaiser deference to the executive order. We just do not see the executive order as, a controlling legal document to which we are claiming deference here. It is playing a factual role here, which is showing very clearly that this was solicited by the president. You don't have to have any doubt that the president himself solicited the preparation of this advice here. But functionally, if this had happened by speakerphone, if it had happened by an internal memorandum, the outcome on privilege would be the same. It just, the public would not have known as much that this was a priority of the president, and likely not as many FOIA requests would have come in. But the fact that the president chooses voluntarily to announce something publicly that he doesn't have to doesn't mean that we have waived our right to assert privileges that would otherwise apply as to presidential communications.
And I had the impression that some of the agencies did go ahead and implement some aspects of the capabilities that they reported. Is that right, or am I misapprehending?
That's right. That's right. A lot of the ideas, frankly, although they were, for many agencies, they were deliberative at the time that they were submitted to the White House. The White House ultimately said, okay, these sound like good ideas. The president approved the slate of ideas put before him to the extent they were called to his attention. And so those things were then implemented. And so
were any of them implemented before they were reported? Do we know? Is there anything in the record on that?
Well, I believe the fact sheet that came out in September 2021 was more or less contemporaneous with the strategic plan. So yeah, there had been some back and forth ahead of the 200-day reporting requirement with the White House. But as our brief states, that was done with White House knowledge and approval. Those things were announced because there had already been, the back and forth exchange between the White House and the agency. So, I think the best way to think of this is a snapshot in time. Some of the things listed in here are things that have just happened. Some of the things are ideas that the agency is just waiting for the White House to say yes to. Some of them are ambitious possibilities or off the wall ideas. One agency came up with ideas for another agency as to what they could do for voting access ideas. So this was a comprehensive exploration of all policy alternatives. The strategic plans gave a snapshot in time. To the extent plaintiffs want to know about the operative commitments and effective policy of the agencies, they're welcome to ask the agencies, as many other organizations have done. If they can't already find that information on the agency websites, because of course, the whole point of this is to help get the word out about voting access and voter participation. So much of the actions taken by the agency have been touted by the agencies themselves without the need for FOIA. Thank you.
All right, Mr. Epstein, you have your rebuttal minute.
Thank you, Your Honors, and I will be quick. The appellees have just told you that all that the executive order is factual evidence. Well, that is precisely the policy argument that I think this court needs to move against, which is to say that executive orders are regulations. They have the force and effect of law. And when you issue them, you're issuing them as final to direct decision-making by the agencies. If an executive order simply becomes factual evidence, then an executive order is not distinct from a template. It's not a public document published in the Federal Register, is no longer distinct from an internal communication by the White House with the agencies. And this spells terrible policy consequences. In fact, we understand the policy consequence, which is that the appellees say that the remedy for the FOIA and transparency community is come up with a fishing expedition to all of the separate agencies. Make sure you tailor your FOIA requests differently for each agency to get all of the potential responsive information. And of course, go and litigate that because you don't know, in fact, what's there. Well, we do know what in fact is there, and that's what executive orders do. And that's why—
May I ask you, counsel, given the situation where we've heard a lot of argument already, I want to know what your position is now. I had originally thought that your organization would welcome an executive order that outlined exactly what the White House was seeking, all right? And then having that heads up, FOIA requests could be submitted to the agencies as to what they were doing and maybe what they were thinking about doing and see what response you had. The other way, excuse my voice, by a microphone or emails would make your burden much more difficult in terms of knowing what is the White House doing. So it says, and as I understand your attack on the what the White House is doing, is I understand your attack about it would be helpful if some words had been included, etc. But you don't really attack the declarations or the fact statement. And I need to understand what precisely is the injury that your organization is objecting to. Because I think questions by my colleagues have whittled away a lot of the broader challenges. So I want to be clear where you are now.
Your Honor, I think to answer your questions and concerns, our position is a plain reading of the executive order says in certain sections, the president will receive recommendations. And there are, in fact, unlike my colleague Appellee, there are magic words in the executive order. There's the magic word recommendation. It just so happens to not be in the sentence in section 3B. And for the public, there is an important need to know, when is the executive, the chief executive, saying that he needs recommendations and advice, to which we did not submit a FOIA request for? And when is he saying, then I need final agency plans? And I think here the injury is that if you look at all of the factual record, the use of the documents, the standard is what is the use when the document was created? And here, there's nothing to contradict that the use for these plans when they were created, before they went through a series of back and forths with the agencies, which Appellee notes that there was spitballing. That initial use, before it ever got submitted, that is an agency purpose, and that is not something that interferes with presidential decision-making. It's something that truly interferes.
You know more about this than I do, but as you know, in this complex form of executive branch government we have, you're not sitting down face to face with the President of the United States for 3 or 4 days going through agency proposals. That's not the way it works. So you have this other system, and I want to understand, because I thought you made some good points, is what is the baseline objection here? I mean, you knew this is what the president wanted to do. The declarations that we have filled out, you know, I know, it may not be in the record, you know, about how the executive office of the president works in terms of gathering information, in terms of making decisions, whether it's on the budget, whether it's on foreign policy, whatever it is. There's a lot that comes in. There's a lot that's winnowed through. And then there are things that are reviewed directly with the individual who is the president. So what is it that your organization thinks here it was denied a legal way to get information, either directly from the agency or through these FOIA requests that we're advised were filed at the White House, to which it responded?
Yes, Your Honor. Our injury was that we reasonably interpreted the executive order to state that agencies should create plans. Plans are normally thought to be final agency actions. A lot of FOIA requesters thought the same thing. And then in the middle of litigation, not before, not at the time of the executive order, we were told these are subject to presidential communications privilege on the basis of a lengthy affidavit by a special counsel to the president. And our argument is that these documents are for a primarily agency use, were created for the purpose of an agency use, that subsequent deliberations between the agencies and the White House are presumed to be subject to PCP, but that ultimately—
Subject to what?
Sorry, Your Honor, presidential communications privilege,
Yes.
but that ultimately the release of these documents, or at least saying that they're not subject to privilege, under presidential communications privilege, would not interfere with the president's ability to obtain confidential advice and make decisions.
Mr. Epstein, you mentioned in your primary argument today the case in the Middle District of Florida, and I thought you said something about remand for segregability analysis. The court has not remanded for any segregability analysis there, has it?
Well, so it's not yet in the appellate court. It's still in suspended animation before the district court. The judge has not issued any final rulings, but he has reviewed the documents in camera.
Right, and so you've requested a segregability analysis, but there's no order there to that effect.
No, and the lower court judge did not conduct an in-camera review.
Thank you.
Thank you very much.
The case is submitted.
Uh, 12. Went on 13? Yeah. Oh, great. Yeah, he should be here, but he's still on. Lengthy August vacation.
Case number 23-5186. Caitlin E. O'Hare, appellant, versus Martin O'Malley, Commissioner of Social Security. Ms. Benna for the appellant, Mr. Littman for the appellee.
Good morning. My name is Christine Baina. I'm here today representing Caitlin O'Hare. We want to emphasize just 2 points quickly. We're asking you to find Ms. O'Hare disabled, but we're not asking you to weigh evidence. You won't, so I don't. With controlling physicians' orders and opinions and uncontradicted sworn testimony, Ms. O'Hare has established her disability as of December 8, 2012 by law. It's uncontested that she collapsed at work on December 8th and that there were uncontested doctor's orders and an unsuccessful work attempt until about mid-March of 2013.
Well, you said there were uncontested doctor's orders, but I think the order you're referring to said until further consultation, a few days.
I'm referring to the very first ones when she went to the hospital and she was in and out and they just wrote she's in and out. I'm not talking about the ones that are contested later.
But you say in your brief that she was ordered to stay in bed for an extended period, but I don't see the order saying that.
You don't see, I'm sorry?
I do not see an order so directing her.
Oh. No. There's not an order directing her. The only thing that is in paper.
Well, you say in your brief on page 3 of the reply brief that she was disabled from March 2013 until May of 2014 under doctor's orders because her primary care physician ordered her to stay on partial bed rest for 14 months. But the cited document from Dr. David ordered her until further medical evaluation can be completed, which does not support an order to stay on bed rest for 14 months.
Yes, ma'am. That's entirely correct. There are a series of communications with her employer. And they're not, I'm afraid in the official record, they are not in order. But it's back and forth. She's still on bed rest and her doctor is communicating. But it doesn't matter very much how long that went on, because about 2 weeks later, after she was put on partial bed rest by Dr. David, her primary care physician, she saw a cardiologist. And the cardiologist, according to her her cardiologist advised her to elevate her legs to relieve the blood pooling that was going on in her feet. And that was her uncontradicted testimony. His notes for that date also reflect a discussion of therapeutic options, for which this would have been one. The other, of course, would obviously have been the compression stockings. But his orders were never rescinded.
Which doctor are you referring to and what page are you referring to?
I believe it is Joint Appendix 292, ECF 17-9 at 7. I don't know which doctor that is, I'm afraid. I believe that's one where there's also present an intern or something. But I believe it's at 292.
You said you had 2 points?
Oh, he just talks about discuss therapeutic options. He doesn't list them. But this is compression stockings and elevating your feet above heart height are standard advice for people with postural orthostatic hypotension.
So
And she has to come, I'm sorry.
absolutely, yes. So I think one of the key things you relied on for the argument that she needed to elevate her legs is Dr. Solomon's final note.
Yes.
And what the ALJ says is, first, he's very careful in that final, sorry, not his treatment note, but the medical source statement. He's careful to note that this is per the patient. And second, he says it seems to be contradictory to Dr. Solomon's own earlier, his last treatment note in November 2015. Why are those 2 points incorrect?
I always have trouble with his ideas of contradiction because, as you just stated, they're months apart or weeks apart. Sick people don't stay the same, especially when it's one where her posture changes her blood pressure.
Absolutely appreciate that. And I think what the ALJ was saying is the last treatment note from Dr. Solomon is in November 2015, and that's the last time that he had seen her. And that it seems, it doesn't say anything specifically that she doesn't need to elevate her legs, but it is otherwise a very positive report
Yes.
on her status.
Mhm.
And that if he did not then see her again, and his final note says she needs to elevate her legs per patient,
Mhm.
that the ALJ had some reason to not give that full weight. And the question before us is, why is that an unreasonable conclusion?
Couple of reasons. First of all, he's a treating specialist, as you know. And that means that he has been in communication with her on and off all along. So he already gets, under Rule 1527C, he gets 3 points, if you will. Of course, she changes, her condition changes, not position, condition changes. And at that time, she had improved. then again, she relapses. She does improve periodically throughout this period, of course, but she also relapsed every time. And in fact, in here, she relapsed to the point that she needed home health aid.
You refer to a doctor, a treatment record showing that somebody had directed, I think it was Dr. Solomon, but somebody had directed her to elevate her legs. I don't recall seeing that. What page are you looking at?
That is the only place that will appear in the record in clear terms, the way you're talking about, Your Honor, is at the very end.
Can you give me a page? There's just a lot of.
When they're doing the, I'm not sure they ever actually say it. They say she needs to elevate, he says she needs.
He who? Dr. Solomon?
Dr. Solomon, same doctor. He says that she needs to elevate her legs when symptomatic.
Yes, this is on page 618 and 619 of the joint appendix, and that's the document I was asking about.
Exactly.
In particular, the ALJ pointed out every time he says that she needs to elevate her legs, he's careful to say per patient.
Right. And one of the important things there is that he actually noticed in there that it's clinically supported by her tachycardia and tilt table testing. But in addition, he also got emails from her 2 or 3 times a month because her blood pressure fluctuated so dramatically.
Thank you.
Thank you. Are you, did you save any time for rebuttal?
I did. 5 minutes?
Okay. Now we'll hear from Mr. Lippman.
Thank you, Your Honors. Jared Lippman for the United States of America. May it please the court. I want to start by confirming a few things that the court pointed out. First, Judge Ballard, you're correct. There's no order directing the plaintiff to stay in bed for 14 months. All we have is the March 2013 opinion submitted by Dr. David, which actually suggests a period of bed rest for maybe 2 to 12 weeks. And that was because she wasn't treated at that time. What the record showed is once she was treated with that medication, her symptoms began to dissipate and her problems began to lift. So you're right, there is no document about her having to stay in bed for 14 months. Secondly, Judge Garcia, you're correct. Dr. Solomon's opinion was overtly per patient. Dr. Solomon indicated right on the face of that when those limitations were per patient. So you're exactly correct there, that those are subjective self-complaints.
So I have a question about that, because most of the diagnostic work that I think doctors do is based on information reported by, obviously, lab tests and physical examination scans are incredibly powerful diagnostic tools, but a lot of information that is relied on by doctors is patient self-report. Can you help me out in understanding why dismissing something as self-report is not deeply problematic?
A few things. First, I wasn't dismissed purely on that basis. The ALJ correctly pointed out where Dr. Solomon made notations that the limitations were per patient, and under the regulations, an ALJ can discount medical opinions for 2 reasons. One, if there's no supporting laboratory or diagnostic testing, or if it's inconsistent with the evidence of record. So yes, of course, what you report to your doctor is relevant. I mean, it does mean something, but in terms of giving a medical opinion controlling weight, it has to meet certain standards to be entitled to that controlling
So
weight.
here, is it that it's inconsistent with lab tests or that it's contradicted?
There is, with respect to like the elevation of legs, for example, that was one of the notations that were per patient. What the ALJ pointed out is there's nothing in the treatment record, one where plaintiff reported that she needed to elevate her legs. In all that time when she's going to her doctor, she
Reported that to Solomon,
she reported that to Dr. Solomon at the time.
who was a treatment doctor.
Who he indicated that in the statement, but nothing in the treatment records. So she never told during the portion of the treatment evidence, she never said, "The doctors, I need to elevate my legs because I have swelling. You know, that makes them feel better." What we do have is her doctors were saying, because of your symptoms, you should wear compression stockings. That should be sufficient, that conservative treatment. And it's proved out that it was. We don't have anything from her doctors in the treatment record saying, you know, if you experience swelling in your legs, you know, to elevate them. They told her to wear compression stockings. You can go exercise and do yoga is the message that they were telling her.
Her argument is that that's not actually contradictory evidence. It's just evidence that doesn't speak to the question. And so it seems to me that you need us to think it's reasonable to read a treatment note that just doesn't mention one way or the other a need to elevate your legs as contradictory to Solomon's later statements. And so what's the argument that we should do that?
I mean, I think it's certainly, you know, everything has to be factored in. The judge is looking at this entire record, and here the fact that it was never reported to her doctors that she needed to elevate her legs, and second, that her doctors never instructed her to elevate her legs, is something that the ALJ can consider when looking at that medical statement, you know, further down the line saying, per patient, she needs to elevate her legs. You'd expect to see that, you know, in the record. And Dr. Solomon, it wasn't just the per patient notations. The ALJ also spoke about Dr. Solomon only saw plaintiff 4 times over the course of several years. That's not the type of longitudinal treatment evidence that sometimes you would see that really underlies the treating physician rule. So 4 times over the course of a couple of years. And important.
But she was in contact with him in between quite frequently by email.
I think those emails came towards the latter portion of the disability period, more in, I think, late 2015 and 2016. So, but the in-person examinations, which is a big portion of this, we're talking about a cardiologist. So testing, of course, is an important component of that. Dr. Solomon saw her only 4 times. So that's another piece of this. It's in addition to a lot of the notations being per patient. Only saw her 4 times. And the ALJ didn't stop there. The ALJ pointed out, and Judge Garcia, you mentioned this, in the last treatment note from Dr. Solomon, which was only 5 months prior to the statement, Dr. Solomon did do an examination and did make notations saying that plaintiff dramatically improved on her medication. She was doing very well from a cardiac standpoint. She had no chest discomfort, no shortness of breath on exertion, no palpitations, no fainting, and no swelling. And that's on page 736 of the joint appendix.
Your brief acknowledged that Ms. O'Hare was, quote, almost completely immobile, close quote, for a year and a half. And then you proceed to say that her symptoms began to respond. But how does that her symptoms begin to respond undermine her having been on bed rest for a year and a half?
I don't believe that we conceded that she was on bed rest for a year and a half. I think that was a contention of plaintiff. She was most certainly not on bed rest for a year and a half. What we have, the timeline was in December 2012 is when she had that first incident at work and she went to the hospital. In March 2013, she made an attempt to return to work. That attempt was unsuccessful. That was light, semi-skilled work. She was working at a boutique in Bloomingdale's.
So you talk about Dr. Solomon's report that she had been almost completely immobile, but then she had stopped fainting. You say the ALJ doesn't credit this. To the contrary, the ALJ treatment note reflects that her symptoms began to respond to medication. Oh, I see. And you say in 2013, how do we know how? I mean, beginning to respond can be slight, it can be moderate, it can be obviating all symptoms. Beginning to respond is mean, I had a bunch of questions, I guess, about the use of something being controlled, something being improved, responding. It seems like every time there's any improvement, one way of reading the ALJ is that that meant it was better. It was better, not in the relative sense. It was resolved. Any light that you can show on, that you can throw on that?
Yeah, I understand your point, Judge Pillard, but when I read the ALJ's decision, I don't think the ALJ discussed improvement in a vacuum. If you look at the ALJ's decision, for example, on page 50 of the joint appendix, this is part of the ALJ's decision, what the ALJ said was plaintiff's POTS improved dramatically. Right, in a vacuum, that doesn't tell you much. What does that mean? But the ALJ does not stop there. The ALJ says plaintiff's POTS improved dramatically on 4NF and midrogyne. And then the ALJ went on to say, although not back to baseline, she had stopped fainting. So the ALJ always added context to when he said that plaintiff was improving. Similar with respect to plaintiff's headaches. This is on page 51 of the joint appendix, also the ALJ's decision. The ALJ said that on medication, plaintiff's headaches were well controlled. I think you're right, Judge Bard. In a vacuum, that doesn't give you necessarily much information. But then what the ALJ went on to explain, that plaintiff experienced only one episode of her headaches over the course of several months. So always adding some context to what those words mean.
That I found difficult about this case is there does seem to be some amount of overclaiming. And then the ALJ is responding to that. For example, in the headache paragraph that you're talking about, the medical evidence does not support her allegations regarding intensity, persistence, and limiting effect. And, it's under control, but then she sometimes is fluctuating. So, the medical record does not support her, but it seemed like she was still, like, it's unclear that the treating physicians seem to be saying she's still got some pretty substantial impairments to contend with. And so taking it down from her level of report, I'm just not sure what to make of that. And that's how I read the ALJ to be using that as a benchmark and saying it was less than that.
What the ALJ does, one of the components of the ALJ's decision is they need to look at the plaintiff's subjective complaints. And then they need to compare that to the medical evidence in the rest of the record to see whether it lines up with her allegations as to the persistence of the problems, as to the severity of the problems, and as to the degree of her problems. And that's exactly what the ALJ did here. And we need to remember, it wasn't that the ALJ said, no, Ms. O'Hare, you're fine. You can go back, to go work, a medium job or heavy job. We're talking about a functional capacity of light work, and the ALJ identified sedentary, unskilled jobs with a sit-stand option. That's the lowest level of work available under their commissioner's regulations. So the ALJ didn't say, you don't have problems. The point was, evidence doesn't support your allegations that you're making. And the medical evidence supports a functional capacity of finding of sedentary and light work.
If we hypothetically thought that ALJ's decision was only reasonable as to the sedentary work finding, would we still be affirming?
Yes, Your Honor, you would affirm in that circumstance.
Anything else, Judge Rogers?
Yes, I just have one question. Counsel, in the opening brief, there is an attempt to summarize. And basically, and it was reflected in the oral argument today, this is a woman who's 27 years old, and yet she has conditions that suggest she's impaired to a far greater extent than would a healthy 27-year-old person. So what's happening? So her record says she has these problems. There are multiple problems. And when they all gang up on each other, she's impaired. But with medication that helps some, she improves in that area. Likewise, with these stockings, with some exercise, she might improve in some other areas. But then the record shows she has relapses where these conditions come back. So the way I read this record and what the ALJ is saying is, this is a person who, throughout her life, is going to have these episodic occurrences that will, in effect, and I'm not using this in a technical sense, disable her from working productively, except in the most sedentary, non-demanding jobs. And that's enough under the law and regulations to find that she is disabled for purposes of medical insurance coverage. Is that basically the position in this case?
Yes, Your Honor. Couple points I want to make here. First, you don't have to be pain-free or symptom-free in order to be able to return to work on a regular basis, particularly here where we're talking about sedentary work. You know, there's a lot of people who go to work on a daily basis that are experiencing some level of symptoms. The ALJ's point here was that the symptoms that, when treated, which they were on medication, did not reach the point of disability. Remember, this is a pretty strict standard here. It's someone who, for a period of 12 consecutive months, not just can't return to her past relevant work, but can't return to any job available in the national economy. And that's the decision that the ALJ made. One other point I want to make, Judge Rogers, is the ALJ didn't ignore or disregard that at times symptoms return. The ALJ addressed that head on. And if you look at page 50 of the appendix, the ALJ says, although the claimant reported increased symptoms at times, her symptoms improved quickly with medication adjustments. So what the record shows is that plaintiff would be stabilized at her medication. At sometimes she came back and reported, hey, I had a spike in my symptoms, doctor, you know, what should I do? And doctors always responded accordingly and those symptoms dissipated again. So the ALJ recognized those, what can be called, recurring symptoms that would pop up once in a while. But in every one of those circumstances, her doctors responded with a medication change or just a dose change, and those symptoms quickly alleviated again.
So Mr. Littman, does controlled mean eliminated or virtually eliminated? As a medical matter?
I wouldn't consider, controlled a medical term. I think what controlled.
You would not?
Excuse me?
You would not consider it a medical?
I mean, we see it in medical records all the time. I'm not sure if there's a medical definition attached to it. I think it's the common understanding of controlled. I think it means that the symptoms have remediated to the point that it's not a significant interference in performing daily activities.
So for example, and this is sort of combines the two concerns I have, that the ALJ is taking aim at the claimant's description and finding the claimant's descriptions to be higher, of worse impairment than the record would show. And the ALJ then is also looking at reduced symptomology. Neither of those things actually, logically to me, seems to speak to the objective degree of impairment and the ability of the person to do work. And I'm looking at I guess it's the third full paragraph on JA 52. Claimant alleges, a couple of sentences into it, claimant alleges she is able to walk only 10 minutes, stand 5 minutes, sit without her legs elevated for 20 minutes, and lift 5 to 10 pounds. The objective medical evidence and the claimant's own reports to her treating sources fail to support the symptom severity and degree of limitation, she now alleges, which in my mind raises the question, well, what degree does it support? The medical record shows the medication has been effective in reducing and ultimately controlling most symptoms. not all symptoms. And physical examinations have generally not revealed significant abnormalities. What about the symptoms that aren't controlled? What about the significant abnormalities that are revealed at the medical appointments? And then the ALJ acknowledges that she has chronic fatigue syndrome. So that's reasonably expected to make her exhausted. I'm just not sure what's going on when I read that.
I think that there are a couple points. First of all, again, someone doesn't have to be symptom-free in order to be found not disabled. There still can be symptoms. And what the ALJ did, the ALJ made these statements, but then went through the medical evidence and discussed what those treatment notes from Dr. Solomon, the cardiologist, and what the rheumatologist said that didn't support the extreme limitations that plaintiff was stating. And remember, we're talking here about sedentary work. So the ALJ, in fact, credited plaintiff to a pretty significant extent, right? I mean, sedentary work is the lowest level of work under our regulations. The ALJ didn't have to defer to what plaintiff, was saying or what she testified about. The ALJ assesses that against the medical evidence and reduced her to sedentary, unskilled work with a sit-stand option. And the one other point I want to make, and it hasn't come up in my argument somehow, we're talking about the substantial evidence standard here. And that's absolutely, critical in looking at this case. And, under the substantial evidence standard, the evidence would have to be so strong that it would compel different factual findings. Just because some evidence might support a different factual finding doesn't mean that, the court should remand on that basis. So long as substantial evidence, that's more than a mere scintilla of evidence, supports the ALJ's decision, then the court should affirm. Also under that standard, the courts can't reweigh the evidence. And the majority of what's being said here is a request for the court to reweigh the evidence, which isn't permitted under substantial evidence of review.
And the consultative physicians are people who look at the records. They don't meet with the patient, right?
So there's two different types of doctors here. There's a state agency consultants, and those were the ones in February upon initial review, and February 2014 upon initial review, and I believe April of 2014 upon reconsideration. Those doctors are just looking at the medical records. There's also something called a consultative examiner, and here we do have one, Dr. Wangard, looked at plaintiffs' alleged mental limitations, and that is someone who actually did examine plaintiff.
Thank you. That's helpful. Other questions?
There are no more questions from the court. We ask the court to affirm substantial evidence supports the ALJ's decision here. Thank you.
Pardon? We had no time remaining. We'll give her a couple of minutes.
Just a couple of quick points. Dr. Solomon is a private doctor. He is not an agency doctor, so he doesn't tell you everything. They write down what they think is important. They also, because they're members of the GW Medical Associates, they see each other's records. So they see all of her tests, examinations, everything. Now, one of the reasons you're having your questions, I realize, is that the judge failed to put in the required function-by-function analysis. Social Security ruling 96-8P and 404-1529C talk about the function-by-function analysis, and it's missing here. The regulations require an evaluation, not, oh, she's generally improved. She does this generally. That should be a number. The function-by-function analysis actually requires the ALJ to evaluate the restrictions and the treatment, their frequency, their duration, and gauge their severity. And that changes in this case over time. But he gives the impression that she's always improving. Well, if she's always improving, why is she sitting at home with her legs elevated? Why is she still going to the doctors? Now, her testimony was that she elevated her legs, and that means you can't work at a desk. If you elevate your feet to heart height, you cannot work at a desk. You can't reach it. She says she elevates her feet most days, most of the time. Most of the time on most days, I have it backwards. She is not bedridden. She can go to the doctor. She can go out to lunch. But for several hours of the day, most days, most of the time, she has to have her legs elevated. And that's the critical core of this case. Yes, she had periods of improvement, but also what would happen is her blood pressure would get better, but her migraines would go up. She would take her migraine and her depression medication, and her blood pressure would go up. And that's in the record as well. Also, the ALJ here failed to quantify, and this is required and discussed in 96, Social Security Ruling 96-8P, they have to quantify separately each of the 7 strength demands: sitting, standing, walking, lifting, carrying, plus manipulative functions, mental functions, postural functions. That's missing and totally missing here in this decision. It's just also what's missing is what happened to Butler. But it's a very poor decision, and it's very difficult. I understand that. But there has to be a function by function analysis, or you don't, or just as you are having trouble, you can't tell what he thinks about what her condition was 1 year versus the next Tuesday, or it's, I wish it were more clear. Well, I actually don't, but that's what's missing. And you can, it's in 404-1529C, but it's expanded, of course, and discussed more thoroughly in 96-8P. And that's why you can't tell when she improved, or critically, how much. You can't tell when she relapsed and how. Because there's no, it's effectively no timeline, is one way to think about it.
What are you pointing to as requiring a function by function analysis? Because I don't think our court has held that rule does.
Social Security Ruling 96-8P. It discusses how the judge is supposed to develop the residual functional capacity. It's also discussed, Your Honor, at 20 CFR 404-1529C.
And you did not include in the appendix the Social Security ruling that you're talking about.
96-8P.
Yeah.
I have a spare copy.
Sorry, we can look it up. And the other thing you're pointing to is.
Oh, in the ruling
20
itself?
CFR, no,
I'm
20
sorry?
You also referred to, is it 20 CFR 416-945? Is that what you were referring to?
I'm sorry?
416-945?
Yes.
Right. Any questions? Judge Rogers, any further questions?
No.
All right. Thank you very much. The case is submitted.
Thank you very much.
Hello?